Hi, everyone. Welcome. Thank you so much for joining today for our Title IX team meetup. If you are new to our team meetup, just to tell you a little bit about what this is. So we actually started this in the summer as a way for Title IX administrators and practitioners to have an opportunity to meet and talk about Title IX matters. So we knew that all summer everyone was scrambling to trying to figure out what was going on with Title IX, how to implement it, and so we wanted to give a space to do so. We were meeting on a weekly basis, but now we have scaled back. Ever since August 14th, we're meeting on the first Tuesday of each month from 12:30 to 1. Now, obviously, today is not the first Tuesday of November, but as you all know, we had something a little bit more important to do on the first Tuesday of November. And so we rescheduled our meeting for this month for today, November 10th. Please do note, however, that we will be moving back to our normal first Tuesday of the month beginning in December. If you would like to find out more about these types of gatherings, as well as other webinars and resources that we have available, you can subscribe to our Title IX alerts and other alerts from Franczek PC on our website. The website is listed here, www.franczek.com/subscribe. And you can go there and sign up for our alerts, and then you will receive notice of these team meetings going forward, as well as all of our other thought leadership and insights. In addition to our alerts that you will find on our website, you can also find our blog, which is Title IX at title9insights.com. So TITLEIX insights.com. And that is focused on Title IX specifically. And it includes information that will be useful whether you're a K-12 Title IX administrator or practitioner, or if you are higher education. So please check those out. Also, please check out our webinars on YouTube. You can also find them on our web page under events. We do on YouTube have a Title IX channel where we have all of our webinars that we've done in the past. You can watch them. These are free resources. You will see that not too long ago, we did a blog post on Title IX Insights about the importance of using free resources for Title IX training. And obviously, we've got a lot of information out there that you can use, which you can find on our YouTube channel. And you also can subscribe to that YouTube channel so that you will receive information about when a new post is made. And this this presentation will be added to our YouTube page, and the materials will also be available online for download as well. So what are we going to talk about today? So today, we don't have a whole lot of time together. As usual, this is only 30 minutes, but we want to start by focusing on what we had advertised we were going to talk about today, which is the significant amount of informal guidance that OCR has given us since the Title IX rules were released in May, and also, even more importantly, since they became effective on August 14th, 2020. So to start out with, I'm just going to give a brief background, sort of an administrative law primer on the difference between the formal and informal types of resources that we get from the Department of Education's Office for Civil Rights on Title IX. After we talk about that, we'll go through a little bit of what we've learned from some of the informal resources that the department has made available since the rules went into effect in August. And then we will talk about the election. I know that many people are already very interested in knowing what, if any, impact a Biden presidency might have on these new Title IX rules. Now, we know that right now Biden is the projected winner. We know we don't have a final answer at this point. However, we also have heard from many, many of you that you already would like to be thinking about and preparing for what could happen beginning as early as January 20th on Inauguration Day if there is a swearing in of a Biden administration. All right, so let's jump in. So the first thing that we were going to talk about is that formal versus informal. What do we mean by formal versus informal? Well, the most formal resource that we have available on Title IX is the law itself. It's 37 words long. It's Title IX of the Education Amendments of 1972. Under that, the next most formal type of law is the regulations. So, although they are not a statute like Title IX itself, regulations do carry the force of law. And they are issued using a process called notice and comment on proposed rulemaking. So the idea here is that members of the public are allowed to weigh in on what will be in the regulations because they do have the force of law. So this is what happened with the current rules that we have been working with all summer and all fall that became effective on August 14th, 2020. They were proposed by the Department of Education, and then the public was given an opportunity to give comments, to which the department responded before issuing a final rule. Now, that is a long process. And so, what we've seen from lots of agencies, not just the Department of Education, but lots of federal agencies, will use guidance, usually in the form of a Dear Colleague letter, another letter to the public that sets forth what the department sees as its interpretation of the law. Now, that guidance can be both formal guidance that goes through that same rulemaking process that regulations go through. It can also be informal. And informal guidance is issued without going through rulemaking, and it generally has not been given as much respect as formal guidance or regulations from an agency. However, under the Obama administration, between about 2011 and 2016, Title IX was basically governed using informal guidance. That was what the department gave us to work from, and we relied on it very heavily in guiding all of you in how to comply with Title IX. When the Trump administration took over, there was a lot of criticism of the Obama administration's use of informal guidance because it does not go through that notice and comment period where the public gets to weigh in before it's finalized. However, the Trump administration from almost day one began using informal guidance as well. So the Trump administration very quickly rescinded most of the guidance that the Obama administration had put out, and they put in place their own informal guidance while the rulemaking process was going on. And so in 2017, for instance, there was a rescission of some very important Obama era Title IX guidance, but there was also a 2017 Q&A that was issued by the DeVos Department of Education that included some new interpretations of Title IX that, again, we advised you to comply with. So it's not that informal guidance hasn't been used since the Obama administration ended. The Trump administration has used it. However, they did issue this final rule in a hope that it would have a little bit more staying power. It would be harder if a new administration came in to just overturn it the way the Trump administration did with the Obama informal guidance. So, in addition to guidance and below it in level of formality, there's what I call the really informal stuff. So, this is, first of all, for a long time, we've looked at information in decision letters and resolution agreements from the Department of Education's Office for Civil Rights to give us a little bit of a sense of how OCR was viewing certain laws, including Title IX. But now, under the Trump administration, we've seen a lot of other informal guidance. We've seen presentations in the form of webinars. And we've also seen more recently some information through what is called the Open Center, which is a center through which individuals are allowed to send questions about the civil rights laws that OCR enforces. They've also recently set up a new Title IX email account that, if anything, I think of as like a helpline that they say you can email for guidance. And they also have a blog. So we have joked a little at Franczek that it's very interesting that the administration that took such issue with informal guidance being used to delineate the landscape for Title IX is now using much, much more informal resources to give us directions on how they will interpret the law through this really informal stuff. So what have we learned from this really informal stuff? I'll start out with some information from that Open Center. So this is an email address that you can email, or there's also a phone number that you can call to ask questions about civil rights laws and specifically about how OCR interprets them. And there have been a flurry of emails that people, including myself, have sent to the Open Center since the Title IX regulations were released in final form in May. I will tell you, as an initial sort of shout out to our friends over at TICSA, which is the Title IX Administrators Association. It's a national association for both K-12 and higher ed Title IX administrators. They actually have a really great resource for their members where you can see all of the Open Center responses that they've received, because the Department of Education isn't making these responses otherwise public. But since TICSA has asked so many questions, there's a lot of information available there. As I mentioned, we've also submitted a number of questions to the Open Center, although as of now, we haven't received as many responses as the questions that we've presented. They seem to be a little backed up and not super concerned with providing responses over at the Open Center. One thing to note is that when OCR does respond to an Open Center question, they do give this very canned language to say that, hey, this is technical assistance. This is not legal advice. It does not constitute our formal policy. We don't provide advisory opinions or determinations about a school's compliance with civil rights laws. That only happens after a complaint has been filed, investigated, and resolved by OCR. So they do give this little disclaimer to say our Open Center responses, you can take them for what they are, but they don't have the full strength of OCR behind them. But that said, I've given you a few OCR Open Center tidbits that we've learned since the Title IX rules were released. So some of them are things like that a Title IX coordinator can oversee the order and decorum of the Title IX process. And this question specifically came up with respect to hearings and the question of whether the Title IX coordinator could serve as a non-voting member of a hearing panel in order to control the process. And OCR said, yes, they can, but remember that the decision maker has to be someone different from the Title IX coordinator. So you need to be very careful that the Title IX coordinator doesn't step into or influence the decision maker's role in the process, but they can be a part of the hearing if you want them to be. I think that that's important even for K-12 institutions where you might not be using a hearing, because it to me suggests that that OCR is recognizing that the Title IX coordinator can play a role throughout the Title IX process to kind of keep the trains on time and to make sure that everyone is doing what they're supposed to be doing, that they understand their responsibilities. I've been referring to this as the mother hen role for the Title IX coordinator. And I think it's a really important reason why we suggest at Franczek that the Title IX coordinator not serve in any other Title IX team role in a Title IX complaint. So not as the investigator, not as the informal resolution facilitator, even though technically they could. But if they do, they might lose their impartiality to be able to play this mother hen role. That I at least think you could interpret OCR's open center response as suggesting is appropriate. OCR also through the Open Center clarified that K-12 schools are not subject to hearing requirements. So even if you offer a hearing, you're not required to use the verbal live cross-examination that is required of higher education institutions. So that's important. There was also an Open Center response that clarified that when it comes to minors, that OCR isn't really taking a position on what rights parents and guardians have during the Title IX process. For instance, they were specifically asked the question, are we as an institution, an educational institution, required to notify a parent if we receive a report of sexual harassment involving their minor student? And OCR said that answer is decided by state law. Just remember that we will consider whether, if you didn't notify parents or guardians, we will consider whether that was deliberately indifferent, whether it was unreasonable in light of the known circumstances. Those of you who've gone through our Title IX training from Franczek know that we recommend that parents and guardians be swept in under all of the notifications and all of the rights that are offered to parties in Title IX when you're dealing with minors. But it's interesting that OCR is saying we're leaving that to state law. We're not going to make a decision. However, we will consider whether it was deliberately indifferent. And then, as with most of their deliberately indifferent standards, they don't really give us much to go on of what that would look like. The Open Center, through the Open Center, we also received clarification on the point that there can be overlap between the second 10-day period of review that is part of the investigation. So you'll remember that there's two 10-day periods of review in the investigation. One is that the investigator must give all directly related evidence to the parties and their advisors with 10 days to respond before finalizing the investigative report. The second 10-day period is that after the investigative report is finalized, the investigator must share that report with the parties and their advisors, and they are then given 10 days to respond to the investigative report. What the OCR Open Center clarified was that the decision-making process, which involves for K-12 schools written cross-examination, doesn't have to wait for that second 10-day period to end. So you can go ahead and start that back and forth written cross-examination process, even if you're still waiting on the response to the investigative report. The Open Center answer was limited to K-12. So just as for those of you in higher ed, it was limited to K-12, a little less clear about how things work out as far as timing with the hearing itself. You certainly can be working toward the hearing, preparing for the hearing in that 10 days. But you're probably going to want to have those statements in response to the investigative report before the hearing goes forward in higher ed. For higher education, the Open Center clarified very importantly that there is a limitation in the regulations if an individual, a party, or a witness refuses to submit to cross-examination during the hearing. The decision maker at the higher ed level is not allowed to consider any prior statements by that individual witness or party. And what they clarified in the Open Center is that that means all statements, prior statements, not just those prior statements made during the hearing. For those of you in K-12, remember that this limitation, it doesn't exist for you. If a person refuses to answer written cross-examination, we aren't told that you must ignore their previous statements. You are given the ability to exclude their previous statements. And you're going to want to work with legal counsel to come up with a strategy on how to do that based on the specifics of your case. So the other informal basis of information is blog posts. So let's talk about what we've learned from these blog posts. Here is just a snip of the blog with the URL for you. You can also find it just by Googling. And then as far as some key tidbits from the blog posts. One of them is that very early on, the Department of Education said the Title IX rule is not retroactive. And what they meant by that, they explained, is that you don't have to apply it to cases where the underlying incident that is alleged to have occurred, if it happened before August 14th, 2020, OCR said they will not expect you to comply with these rules. However, please go over to our blog at title9insights.com and check out our blog posts. Are the new Title IX regulations retroactive? One court says yes. The long and short of it is that a recent decision out of New York involving a higher education case, that the court said that at least in that case and on the facts of that specific situation, that a higher education institution was required to use its new Title IX procedures for an incident that occurred in January of 2020, long before the rules went into effect. So please check that out. You will see in that blog post that we try to give you some explanations of why that case might be unique. It might not be applicable to all of you, but it is very important and it really warrants your attention. OCR also said in a blog post, it said that there's a lot of flexibility for schools, colleges, and universities as to who they use as decision makers, and specifically whether or not they want to use multiple people for that role and whether they want to bifurcate the responsibilities of the decision maker. So you might want to have one decision maker who is responsible for handling the written cross-examination in K-12, the hearing, and the decision of whether or not there was responsibility. You might also then want to have a separate decision maker who's responsible for deciding what sanctions would need to be put in place if there is a finding of responsibility. However, what OCR said was that both the determination, finding responsibility, and the disciplinary sanctions must be contained in one single unitary document, which is the written determination required under the rules. So in other words, the recipient's written determination cannot be issued piecemeal as different parts of the grievance process. Note that this decision maker flexibility thing did not address what I think is the elephant in the room, which is the concern, the conflicts between post-Title IX processes and the Title IX rule. The Title IX rule seems to envision that the individuals who are part of the Title IX team will actually effectuate discipline. But in many cases, whether it's in higher education when dealing with tenured faculty, or if it's in K-12 when dealing with tenured teachers or students, you may have another layer of required process, either from a collective bargaining agreement, from state law, that has to occur and that can't be integrated with the Title IX process. We don't have an answer from OCR on what that looks like. Frankly, it seems as though maybe they haven't been paying attention that this conflict exists. But it is something that we've thought through at Franczek, so please contact us if you need assistance with thinking through how that might play out. Also, for any of you who attended our team meetup last month, which was on the Title IX Big Five, which is employee quid pro quo, and then the VAWA and Clery Act Big Four, which includes sexual assault, domestic violence, dating violence, and stalking. You know that the day after we did our last team meetup, which addressed the Title IX Big Five, that OCR put out a blog post where they clarified the Big Four definitions under Clery and VAWA. Our Title IX team meetup is still valuable. If you haven't seen it, you can still go back and watch it. It still is applicable, but I do encourage you to consider whether you need to update your policies and procedures to make sure that they include the definitions that OCR gave us in their blog. For Illinois school districts, those of you that use PRESS, their administrative procedure does need to be updated. And we do have that ready off the shelf if you need it. Contact me if you would like to get a copy. All right, let's use our last few minutes to talk about the election. What have we learned based on the at least current results of the election? If you head over to our blog, you will find a more lengthy discussion of my thoughts on this, but Essentially, we received very quickly a lot of questions from clients and friends, both directly through Twitter, about what does this mean? If there is a Biden presidency, what does this mean for all of the work that we've been doing all summer and fall to learn and come into compliance with these new regulations? We are all still trying to figure this out. I'm sure that the Biden transition team is even still trying to figure this out. But what I can tell you, the long and short of it is that I don't think we're going to have a situation, even if we end up having the Biden administration sworn in on January 20th, I don't think we're going to have a situation where these rules can go away right away. Because the concern is that if the regulations are still on the books, even if OCR says that they won't penalize you for not using them, you could find yourself in a situation where you have a respondent in a Title IX complaint who says, wait a second, that's the law on the books. I don't care if OCR promises they're not going to take away your federal funding if you ignore them. You can't ignore them because they are my due process rights and protections that are required by law. And so the concern is that, yes, maybe OCR will tell us very quickly, we're just not going to enforce these rules going forward. But even if they do, is that really going to fully protect schools, colleges, and universities from due process complaints from parties in disputes, and particularly from respondents? So while I don't have a clear answer for you, I do encourage you to go over and check out that blog post. I'd love to hear from you on your thoughts or questions. You can always reach us here at Franczek at title9@franczek.com. And if you have any questions, we would love to hear from you, any thoughts that you may have about what this potential change in administration might mean for you going forward. All right, we do have a little bit of time for questions. I don't see any questions pending, but I'll give it just a second longer. If anybody wants to, you can also raise your hand. I am able to allow you to speak if you would like to just jump in and ask a question. You can also ask a question through the chat or through the Q&A. While I'm waiting just to see if anybody has any questions, I will tell you that we are always looking for new ideas, topics for our Title IX team meetups. So if there's something that specifically is on your mind that you would like us to talk about next month, please do let us know, and I'll put in the chat our email address, which is title9@franczek.com, in case you have any questions, topics that you would like us to address. And with that, with not seeing any questions, I will wish you all a good rest of the day, and we'll look forward to seeing you next month on the first Tuesday of the month at 12:30. Thank you, everyone. Take care.